What's going on, everybody?
Who is that cat? Arthur. You just gonna stare at me? Oh.
I am Walrus. What the hell?
Hey, what's going on, everybody? It is Artie of Artie's Corporate Fiction. Happy Friday to all of you. Today it's just gonna be a chill, laid-back stream of researching this Karen Reed case. I'm now succumbing myself to the rabbit hole. I think I found one of the oldest televised or broadcasted hearings from it. So I'll have that up front for you guys. I'm also going to try and I've already read through a bunch of the docket. I think I'm through September of 2023. But I think this oldest entry is from May of 2023 in this hearing. I've been I feel like I should have been taking notes. But that's probably what I'm going to be doing in the middle of it. But we're going to be doing that, and so at least you guys have something to take a look at, because I'll have the broadcast as well as the relevant motions that they're discussing. Also, I'll be reading along with it just to get my sense of what's going on and what's being argued. I do have a lot of things to say so far. It's just like, I want to wait. I want to wait until I'm kind of fully caught up before I kind of give my own opinion on the state, my opinion on the defense, and where, what I think might the trial go towards, ends up, I should say. Sorry. I'm blabbing. But that's kind of like the goal. Eventually, I probably will want to reach out to Kate. But like I said, I want to wait until I get my own opinion. I don't want to be tainted. You know what I mean? I want to be able to come to my own conclusion. And then I can ask questions and, see what I'm missing, because obviously it's not just simply Turtle Boy. There's a lot of divisiveness when it comes to this this case. So I want to be able to kind of take a look at it for myself, and see where I fall before kind of asking questions and everything. So sorry, could be that one of those kinds of nights. Oh, this hearing, I think, takes place. Let me double check this. Like I said, it's the oldest hearing I was able to find. May 3rd. I'm not sure which one it is, but let's go for it.
David Yannetti and attorney Ian Henchy from the Yannetti Law Firm. Good afternoon. Good afternoon, Your Honor. Alan Jackson from Worksman Jackson and Quinn, along with Elizabeth Little from Worksman Jackson and Quinn, on behalf of Kieran Reed.
Good afternoon, Mr. Jackson. Good afternoon, Ms. Little. Good afternoon, Ms. Reed. Okay, so we're here for the Rule 17 motions. Who's going to argue those?
So, Your Honor, there are two motions before the court that we'd like to be heard on. One is the motion to renew our motions to compel, which we'd like to be heard on first, if the court pleases.
Motions to compel. I know that one. So which one is this one? What's the date here? And then the Rule 17 motions. The Rule 17, my understanding, is a desire or a request for documentation or evidence. But it's explicitly stated that the Rule 17 is not to be intended to be like an additional discovery tool. So that's what the Commonwealth likes to argue in their case, because it's defense counsel that's asking for a Rule 17 motion. March. That's docket number 60. Shout out to Kate for sending me the Dropbox for all of these filings, though. Here we go. Defendant's motion for renewed discovery.
And I would be arguing that motion. With regard to the Rule 17 motion for the animal control records, my colleague, Mr. Jackson, would be arguing.
Okay. Animal control records. Okay, that's what it was. Rule 7. So, rule... Let me see if I can find that one. 66. Well, there's two Rule 17 motions. There's one for Brian Albert's, his cell phone. Yeah. And animal control records. Brian Albert, my understanding, is the homeowner of the house. The homeowner of the house where O'Keefe's body was located. Damn it. Where the hell is it? I'm trying to find... Okay. You know what?
Second, if the court pleases.
Okay. All right, I'll hear you.
Thank you, Your Honor. May it please the court. We are seeking immediate access to John O'Keefe's clothing, to all evidence seized from my client's vehicle.
Well, this first one is their motion to compel discovery that they're hearing first. And I think this is what it is right here.
To tissue and other samples from John O'Keefe's autopsy and to the original Canton Library video, which we still do not have. We are asking this court specifically to set a hard deadline for access to this mandatory discovery and evidence. Your Honor, at the outset, it is important for me to emphasize why a deadline needs to be set. It's important to emphasize why time is of the essence for our access to this evidence. It's been 15 months since my client was arrested and falsely charged with killing John O'Keefe. Prior to 15 months ago, my client was employed in two prestigious positions. Prior to 15 months ago, she had a robust health insurance plan that covered her numerous serious medical conditions. But 15 months ago, she lost everything. 15 months ago, these false allegations began to destroy her life, and for the last 15 months, she has been fighting for her life. 15 months after her arrest, she has no income. She does not come from a wealthy family. Her father was a respected and now retired educator. Her family is very squarely middle class. But given that Karen Reed is now fighting for her life, whatever money that they've saved is all going to her defense in this case. She's hired private counsel from 2 coasts. She's hired multiple experts at considerable costs. And when I say considerable, I mean tens and tens of thousands of dollars. And the meter is running with each passing court date. She can't afford to scrimp on her defense because her life is at stake. In the 11th months that this case has been pending in this court, we have continually asked for access to the same basic mandatory discovery evidence. We've been prohibited from inspecting that evidence. In February of 2022, the police seized John O'Keefe's clothing. It's now May of 2023. We haven't seen it, we haven't inspected it, we haven't been able to test it. In February of 22, the police seized pieces of taillight from my client's vehicle, pieces that they claim to have found at the residence where John O'Keefe died, despite the fact that multiple searches initially turned up nothing. Pieces of the taillight were only found after Trooper Michael Proctor, conflicted Michael Proctor, had seized my client's vehicle and had it in his possession for well over an hour. That evidence needs to be put to the test, and it needs to be put to the test now. We have been prohibited from testing it, from inspecting it, from even seeing it. There were tissues and other samples from the autopsy of John O'Keefe to which we've been denied access. We believe that when those samples are tested, the results will be exculpatory, likely case ending. But 15 months after she was arrested and 11 months after she was arraigned in this court, that evidence remains hidden from the defense. The police have maintained exclusive control over the event data recorder and the Lexus infotainment system from my client's vehicle. We have seen neither, and this is simply unacceptable. Prohibiting the defense from inspecting this evidence is infringing on my client's constitutional right to a speedy trial, and it's infringing on her right to due process. It's almost 3 months ago that we last appeared before you, Your Honor. We requested access to these items, and yet again, the response from the Commonwealth was that they would be tested soon. The prosecutor had represented within 30 to 60 days. That's on record. It's now close to 90 days. We've made zero progress. This court did order that the Commonwealth request expedited testing,
Sean.
but that order has yielded nothing. I asked the court to set deadlines then, which the court was not inclined to do. 3 months later, it is crystal clear that deadlines need to be set. Without a deadline, we have no assurances that this case will not drag on who knows how long into the future. With each passing day, my client, who not only is presumed to be innocent, but is factually innocent, remains jobless, with inadequate health insurance, and with each passing day, her savings and her family's savings continue to be depleted. There is no time to wait. There is no time to waste. It is time for excuses to end. As we noted,
Sean, this is supposed to be a chill stream, not get me ultra triggered stream, okay?
in our motion, the prosecution and the crime lab move very quickly when they want to. In other cases pending before this very court, the very same investigators secured DNA testing within 2 weeks of opening their investigation before anybody was charged. Contrast that with our case, where here we are 15 months later, no such testing has even started. Regarding the Canton Library video, this court should know we still do not have relevant time periods. From the Commonwealth's evidence, we know that my client drove by the Canton Library at 12:16 a.m. on January 29th because that was recorded. There is video of her driving by at that time, heading to 34 Fairview, which is where John O'Keefe died, with her taillight intact. We know that my client arrived back at John O'Keefe's residence at 1 Meadows Ave in Canton at 12:41 a.m. because the Commonwealth produced a voicemail that she left for John, where you can hear the garage door closing, the car door closing, the house door closing while she walked in her high heels on the garage floor. 1 Meadows is about a mile from the Canton Library. We know the video equipment was working because they have that footage from 12:16 a.m. But in the video that the prosecution turned over to us, there is a gap in that video from 12:37 a.m. to 12:39 a.m., which would have been the precise time my client would have been driving back past the library. We know that that footage would show that my client's taillight was still intact at that point because she never struck John O'Keefe with her vehicle. Yet the prosecution has produced a video from the library with that crucial time period missing. This evidence is strictly in their possession. We've been told that the Canton Police provided the evidence to them via a share file, the Canton Library provided this evidence to them via a share file link with a guest ID and a guest password. We need that link, that user ID and that password. We cannot rely on Trooper Michael Proctor, conflicted.
I got it. Right now he's arguing that he's not arguing on the Rule 17 motions. He's arguing that the state still hasn't given them like complete discovery, or has only given them partial discovery, or there's apparently bits of video that's missing from the discovery that they've received. So that's what he's arguing right now.
Michael Proctor to sanitize exculpatory evidence before sending it to us. We need the original footage. If the Commonwealth answers that that original footage no longer exists, then we'll need an evidentiary hearing to put the relevant parties under oath to find a way.
No. He's not testifying. He's making an argument. He's making an argument that based on they're alleging that what the video footage that they received from the state is incomplete.
What happened to it? The bottom line here, Your Honor, is that we've spent 15 months trying to uncover the truth. We are not afraid of whatever evidence is unearthed from whatever source, because for 15 months, every stitch of evidence has been consistent with my client's innocence. However long this case lasts, and I sure hope the prosecution comes to their senses and realizes they have no case because they've charged the wrong person. But however long this case lasts, the remaining evidence will drive a stake through the heart of this prosecution. In the meantime, my client suffers. In the meantime, her life is on hold, while she spends every waking moment defending herself, emotionally, intellectually, and financially. We cannot abide by excuses any longer. We need this court's help. We need you, Your Honor, respectfully, to hold the prosecution's feet to the fire. We need this court to order the Commonwealth to stop trampling on my client's rights to a speedy trial and her right to due process. We need this court to set deadlines for the production of this evidence. Thank you.
Okay, thank you. Mr. Lally?
Yes, Your Honor. So, in response to counsel's motion, just in response to the statement that every piece of evidence that's been provided thus far is inconsistent with the defendant's guilt and consistent with her innocence, I would have a large issue with that. But as it pertains to these particular pieces of evidence, counsel's right in that motions were filed. Counsel's right in that motions were allowed when, as related to inspection of said materials, and the Commonwealth has no issue with inspection of materials once they're back from the lab. Now, the last time we were before this court, back in February, the court had asked myself to reach out to the lab and see if there was anything that could be done to expedite the analysis. I did that, spoke with and filed the necessary paperwork with the lab to expedite as much of the analysis that could be done at that particular time. So at that time, what I was provided with was a deadline of no later than May 5th, that those items, at least as far as the trace analysis and the criminalistics was concerned, would be completed, and I should expect something close to that date. I confirmed with the lab as of yesterday that that timeline is still a viable one. The case is currently in technical review, so once that's completed, then we should.
Oh my God, this is annoying.
To counsel.
This is so annoying.
As it pertains to the inspection and the return of the items from the lab to the Commonwealth's, well, at least the District Attorney's Office or the State Police's custody, one of the issues that we've had with that is that in order to facilitate some of the necessary DNA testing some of that testing would be exhaustive. And in particular, there is a hair sample that was recovered from the rear right quarter panel of the defendant's vehicle. It was taken to the lab, and I was informed by the lab that any testing of that for DNA, for comparative purposes to Mr. O'Keefe, would be exhaustive. So on March 10th, I sent counsel a exhaustive testing form that needed to be filled out, whether or not they want an expert present for that testing or don't want an expert present for testing is really immaterial, but I need some sort of authorization from counsel before the sample is subsumed during the course of testing with the lab. I haven't heard anything back from counsel. I spoke to counsel numerous times. I sent emails, and I heard no response as far as that. So as far as the DNA testing is concerned, the delay on that is because I don't have anything back from counsel as far as whether or not they want an expert present, who that expert is, how to contact them, and how to facilitate the beginning steps of that particular testing. So that is why at least in no small part, why some of the items are still contained at the lab is because the testing is still yet to be completed. But I do hope to have the trace and the criminalistics, and I expect that by next week at the latest. And again, whatever deadlines that the court sees fit to, or deems fit to put on certain things, as far as that's concerned, is certainly within the court's prerogative. I don't think that we need deadlines. I don't think that we need an evidentiary hearing as it relates to it, but that's where it stands. As far as the video is concerned, the video was provided by the IT director for the town of Canton. There was a share file that was shared with the troopers. The troopers, upon receiving that, it was Trooper Dunn who received that video, not Trooper Proctor. If I could just speak briefly as it pertains to Trooper Proctor, there is no conflict. Trooper Proctor is not conflicted in this case. I indicated that specifically in some of the oppositions that were filed to Rule 17. So there's been some photograph taken from a social media site which is purported to be Trooper Proctor with one of the McCabe's children who were a witness in the case.
Oh, so wait, so they're still arguing that 7 months later? Didn't they just bring up this sort of this photo with Proctor and the McCabe family in a hearing like 3 days ago? This hearing is from May of 2023.
The child that's depicted in that particular photograph is not one of the McCabe's children. The McCabe's have 4 daughters. That's not one of them. It's a relative of Trooper Proctor. It has nothing to do with the McCabe's and nothing to do with this case. Whatever conflict counsel believes Trooper Proctor has just doesn't exist. Now, as far as the video was provided to Trooper Matthew Dunn of the CPAC unit with the District Attorney's Office, that was then shared with Ms. Crawford. It was a person in our office who specifically who deals with forensic and surveillance video and type evidence. It was then archived on our system. Recently, we reached out and spoke to the IT director with the town of Canton again. That share link I tried to send to council. Email essentially wouldn't go through. We tried to open it. Essentially, it won't open. So the link expired within 30 days within 60 days, if not 30 days, of it being shared with our office. But the exact information that was provided by the town of Canton was archived by Ms. Crawford, was then provided to council at her arraignment in Superior Court, as well as I was able to download it onto a Citrix file, which I then shared with council earlier this week. So what we have as a video, what exists as a video, what we were given as a video for those relevant time frames was placed onto the archived within our system, was then placed onto a disk, and what's on the disk and what's been provided to council is what we received.
Okay. All right, your next motion?
That would be Mr. Jackson.
Okay.
The Rule 17.
Good afternoon, Your Honor. May it please the court. We are, as indicated in our papers, we are seeking summonses, and this is dealing with the animal control issue. That Rule 17 motion, we're seeking summonses directed at 2 entities, the Canton Animal Control and the Canton Town Clerk, both. We believe they both have records. We know they both have records. These are records that we need, the defense needs, to shine a light on Karen Reed's innocence. These are records that are central to our theory of the case, and these are records that we have no other option to get but through a summons. They've indicated to us they have the records, but they need a court order. They need some sort of a summons. Your Honor, in furtherance of this motion, I want to talk for a quick second about a couple of undisputed facts. Undisputed fact number one, on January 29th, 2022, Officer John O'Keefe was found dead in the yard of Brian Albert at his house at 34 Fairview in Canton. That is undisputed fact, where he was found dead and what the circumstances were surrounding that death are why we're here now. Second undisputed fact, when John O'Keefe was found, he had this set of wounds on his right arm. The medical examiner indicated that these wounds were concomitant with his death in terms of the temporal, the time that he died. These were wounds that he suffered at or near the time that he died. And the Commonwealth looks at these wounds and says, there's nothing to see.
Okay, so the argument that they're trying to make it on the motion to compel this, okay, there's two Rule 17. The first one is to the Canton Animal Control and the Canton Clerk's Office. I think that what he's going to argue, based on what I read in this order or this motion, is that they want to raise the possibility that it was the canine dog that was also the family dog attacked O'Keefe.
Here, why are we looking at this? This is, you're following a red herring, basically. This is just a road rash. This means nothing. It has no impact on our case one way or the other. This is, according to the Commonwealth, simply a set of injuries that John O'Keefe suffered at the hands of being struck by a moving vehicle. Well, first, I would ask the common sense question, does this look like a road rash? I mean, the court's got years, decades of experience, life experience and legal experience. Of course this doesn't look like a road rash. It's not a road rash that any of us have ever seen. Or does it look more like claw marks and bite marks from an animal, which is exactly what they are? Second, if it was a road rash, where's the rest of the road rash? John O'Keefe had one set of injuries.
Oh my God. For the love of God, why has Massachusetts not figured out how to mute people on Zoom? That's actually probably going to irritate me more than anything else in this damn case, is listening to the hearings and listening to people clanging, echoing. Oh, okay, yeah, I'm triggered. I'm really triggered already. Oh, okay. Whew. Okay. Anyway, the reason for him is I don't know what dog. I couldn't tell you what dog bites look like a severe dog bite. I'm a layman, and I think the defense counsel is trying to rely on the layman's what a layman would think a dog bite or dog scratch looks like.
Scratches, deep puncture wounds on his arm, on his right arm only, from mid-biceps to mid-forearm and no other place. For instance, mid-biceps and mid-forearm that you might put in front of your face or your body if a large animal was attacking you, resulting in these wounds. Why are the wounds confined just to his right arm? What about all the other pointy bits of a human body? If someone is rolled under a car or rolled in gravel because of the car, what about the shoulders? What about the knees? What about the ankles? What about the elbows? None of that exists. These are the only wounds. They're confined to his right arm, and they're deep scratch wounds, puncture wounds that are indicative of claw marks and bite marks from a large animal. And third, what about the Commonwealth's own expert? She has to have opined about this, correct? She has to have said during the grand jury, I mean, this was a full-throated investigation surrounding the potential murder of a police officer. What does the Commonwealth's own expert say? First of all, She was never asked by the Commonwealth during the course of the grand jury about the injuries. It took a grand juror actually asking the question of the witness, and she said, no, I cannot say that is a road rash. There's certainly not enough evidence to suggest that these wounds are consistent with a road rash. Well, she had to have at least talked about the fact that it was an animal, right? She had to. The Commonwealth had to have asked that question. She actually said nothing about whether or not that's consistent with an animal, because the Commonwealth very particularly did not ever pose that question.
Okay. Or I guess they're suggesting that they did it to hide something. That I think it's perfectly. I don't think there's anything insidious or suggestive by the medical examiner saying that they cannot conclusively say that the injuries are caused by gravel. It's a very specific question. And I think it's fair for them to say, I don't, but they didn't say, but they also didn't say that it was due to an animal attack. And the fact that the state didn't ask about it is not indicative that it was an animal attack. Okay, moving on. All right.
But we did. We hired one of the preeminent medical examiners in the country, a doctor by the name of Sheridan, Frank Sheridan, and he wasn't some deputy medical examiner. Dr. Frank Sheridan was the medical examiner for San Bernardino County in California, with more than 12,000 autopsies under his belt, the supervising medical examiner for one of the largest counties in California, and he concluded to a scientific certainty that these wounds are from an animal attack. Period. Full stop. So, what do we know about animals?
I said gravel, I meant to say road rash, but I get.
Which is exactly where
Oh my
Officer
God.
John O'Keefe was found dead. In February of 2017, we know that the Alberts had a dog. There's a photograph of Brian Albert with a dog, Chloe, in the foreground. By 2019, the Albert family had registered ownership of that German Shepherd. Moving on to 2022, in January of 2022, specifically January 29th, John O'Keefe suffers these animal puncture wounds, these animal scratches, these animal bite marks that are heretofore and up to this date, today, completely unexplained by the Commonwealth. By May of 2022, Karen Reed's defense team starts asking questions about this animal, about these injuries, about the dog, about what dog existed at the Alberts house, where is the dog. We started inquiring pretty significantly. That same month, amazingly, the Alberts informed the Canton Animal Control that the dog was remarkably and mysteriously rehomed. The dog was gotten rid of. And to date, the Commonwealth has yet, as my colleague just mentioned, has yet to release the tissue samples to us for DNA testing to determine if there's evidence in these wounds of a canine attack, which we believe there will be. During that grand jury testimony, Brian Albert admitted to three things. Number one, he admitted that he owned a large German Shepherd. His words, not mine. A large German Shepherd. Number two,
It's a canine. What do you think?
he admitted that the dog was at his home on the night John O'Keefe, early morning hours, John O'Keefe was killed on January 29th, 2022. And the dog, according to his own testimony, was inside the house and never in the front yard, which is where John O'Keefe's body was ultimately found. And the third thing that he admitted was that the dog was, quote, not great with strangers, end quote. That's a dog owner's euphemism for the dog bites, the dog attacks, the dog is mean or can be mean.
What? I mean, the dog not being good with strangers is not, it's not necessarily a euphemism for it being a bloodthirsty monster. But again, this is the defense. This is the defense.
So why wouldn't the Commonwealth ask about these injuries? Why wouldn't the Commonwealth inquire, as we have been inquiring, about the nature of these injuries and their significance in terms of John O'Keefe's death? It's because they know that the answer completely obliterates their case. Their theory of homicide would fold if they got the true answers to these questions. The answer exculpates Karen Reed, and the answer inculpates Brian Albert. That's because if that dog was inside the house that night, not on the front lawn, not in the front yard, but inside the house, and these injuries were suffered or sustained at the time John O'Keefe was killed, then that means John O'Keefe was inside the house when he was killed. And it also means that his body was moved. That's consistent with the facts that we also know to be true, which is not one person that was in that house and ultimately exited that house from that party that night, not one, saw John O'Keefe's body laying in the cold in the front yard. And that's because he wasn't there yet. Multiple people walked out of the house, multiple people who would have no other reason, would have no reason to lie about that. A 200-pound man, 6'2", lying in the front yard on a light dusting of snow in dark clothing. Not one person saw him.
So I will say, and I want to avoid chat because I know chat's going to come up with their whatever explanation they want to. But there are two outstanding questions for me that I have with regards to there are two open issues that the defense has raised that I agree with and I haven't heard a good explanation for yet. I don't want to say them now. I want to wait till later. But there are at least two issues that I have that the defense has raised that I kind of think are worth addressing.
But if John O'Keefe was beaten unconscious in, for instance, the basement of that house, and later moved to the front yard after the guests had left, there's your answer as to why no one saw him. And it also answers two other questions which are looming in this case. Why would Brian Albert rip out the floor of his basement months after John O'Keefe was killed? The second question, why would he sell his house? So in the months following John O'Keefe's death...
Okay, this is actually the stupidest. This is actually the dumbest one. The dog one, I could see where the defense is coming from. It's flimsy at best. Don't get me wrong, it's flimsy at best. But this home sale one is so unbelievably dumb, and I think the Commonwealth calls them out on this in their opposition as well.
The dog has been gotten rid of. Got rid of the evidence in the basement. Got rid of the house, the crime scene itself. Your Honor, I would submit to the court that evidence is literally being destroyed right under.
Oh my God.
It's been reported that the federal authorities have now gotten involved in the circumstances surrounding this case and have impaneled a federal grand jury to investigate some of these circumstances. But Karen Reed should not have to wait for the feds to figure out which heads should roll. I would implore the court, now is the time for the court to take some action and give us the tools, the defense the tools that we need to fully investigate this case. We need these records to track down this German Shepherd, if it's still alive, which clearly is an open question. Our understanding is, at least up to this point, is that the dog was not only rehomed, but rehomed out of state. out of the jurisdiction of this court and out of the reach of the defense, or at least that was the attempt. We need those records to find where that dog is. If the dog still exists, we need a saliva sample, we need a hair sample, we need something, and then we need the Commonwealth to give us the tissue samples that were taken at the time so that they can be compared. This is vital to the defense. We ask that the summonses at issue for the two entities that we've described, those summonses issue, our request clearly meets the Lampron standards. Number one, it's relevant evidence. Number two, we definitely need a subpoena or a summons. They will not provide the information without a court order. Number three, this information is necessary for our defense. And number four, contrary to what the Commonwealth constantly says, oh, well, this is just fishing, I think we've established this is not just fishing.
It wasn't the Commonwealth that debunked their whole, oh my God, they sold the house to hide evidence or something theory. It was Brian Albert's attorney in opposition to the Rule 17.
Fish on the hook. We just need the court to help us reel it in. I will submit on further oral argument regarding the issues or the summonses surrounding the animal control and Canton Town Clerk. If the court has any further questions about those, I'm happy to answer them. If not, I can certainly give the court a preview of the second Rule 17 motion, which deals with the phone records and the actual phone of Brian Albert, but I believe the court has indicated and we've suggested that an evidentiary hearing is in order.
As I understand it, the parties have agreed for an evidentiary hearing, and we rearranged our schedule a bit so that we could accommodate you.
That's perfect.
Okay.
The only thing I would say in furtherance of that, very briefly, is the Commonwealth has suggested that Rule 17 is just sort of a regurgitation of something that we filed back in, I think it was September, that could not be further from the truth. There is new information, there's dozens of pieces of new information that we have.
What I'm going to do because of that, let's let Mr. Lally respond to your remarks on the
Of course.
issue first.
Thank you, Your Honor. Your Honor, first I would state it's an interesting sort of straw man argument as far as it being road rash. Or that
straw man.
Has always maintained that it's road rash on his arm. No one has ever said that but counsel for the defendant. As far as the injuries are concerned to Mr. O'Keefe's right arm and right forearm, they've always and consistently been described as abrasions caused by blunt force trauma, not road rash. I'm not really sure where the road rash comes from. What I would submit in conjunction with that is, again, divorcing whatever evidence the defendant claims from the context of the rest of the evidence and the rest of the case. It's a little peculiar and conspicuously clear from the defendant's fact section that the damages to the right rear corner panel of the defendant's vehicle, embedded within the bumper to that vehicle, is pieces of a cocktail glass. The victim, Mr. O'Keefe, is last observed on surveillance video, external surveillance video from the Waterfall establishment that he left just prior to going to 34 Fairview, with a cocktail glass in his right hand. The same arm that's injured, the same type of glass that is then recovered from the bumper of the defendant's car. As the court is well aware, and I just stated for the record, under Rule 17, the defendant has the burden, or the moving party has the burden to establish that the documents are evidentiary and relevant. Secondly, that they are not otherwise procurable reasonably in advance of trial. Thirdly, that the party cannot properly prepare for trial without such production and inspection. And fourthly, that the application is made in good faith and is not intended as a general fishing expedition. The issue that the Commonwealth takes with the defendant's request as it applies to these particular records is with number 1 and number 4. The Commonwealth would submit that the showing from the defendant is simply insufficient to establish any relevancy or evidentiary value to these records. And then secondly, that this is the very epitome of a fishing expedition. The indication, even from the verbiage that's used by counsel in the motion, sort of sheds light as far as as I just stated, the sort of epitome of a fishing expedition. It's Language such as "it could shed light" or "if true, this fact would undermine the prosecution's entire theory of the case." There have been a couple of theories that are stated within the context of counsel's motion. I can state for the record those are not the calmos theories. No one ever said that the vehicle struck Mr. O'Keefe in the head, and that's...
Okay, could somebody link me a picture, or if there's a picture, or if somebody has like a diorama or like a diorama drawing, a drawing of where exactly the body was located, according to McCabe, Reed, and Roberts, because I don't know where, I don't know. My mind is thinking that he's lying in the front yard of the house, but people are saying he was on the street. I don't know. Based on the narrative that I'm reading from most of these motions, it's like he's supposedly like at a corner of the property. I don't know.
What caused the injuries? That's actually not at all what the grand jury testimony or the evidence has shown throughout the course of this investigation and throughout the course of this case. But those could and if true, those very words by definition evince the very nature of this particular request. The first issue would be with the time frame. As it's stated within the motion, it's from 2015 to present. I'm not sure why so expansive a time frame is needed or necessary or relevant to anything that is a subject matter before the court. As counsel suggests, that photographs of Mr. O'Keefe's injuries suggest that he was severely beaten and left for dead, having sustained blunt force injuries to both sides of his face as well as to the back of his head. That there's evidence of defensive wounds. There's a cluster of deep scratches and puncture wounds to his upper arm and forearm. And then the defendant essentially asked the court to take the then inferential leap that these injuries, which are wholly inconsistent with the injuries noted by both the emergency medical personnel at Good Samaritan, where Mr. O'Keefe was taken immediately from the scene where his body was discovered, and from the medical examiner's finding and sworn testimony. So wholly inconsistent with those, that these are, then take the inferential leap that these are consistent with bite marks or scratch marks from an animal, specifically a dog. In support of these assertions, as counsel stated, there's an affidavit from Dr. Frank Sheridan that the
hey, what's up, Biggin?
Claw or scratch mark.
Biggin Raiders, what's up? Uh-oh. Uh-oh. Hang on. What the heck happened?
What the personnel at Good Samaritan, the doctors, the nurses who examined Mr. O'Keefe when he came into their facility, they described his injuries as a right superior orbital ridge region, approximately 7 millimeter laceration, positive for surrounding soft tissue, swelling, and positive breath sounds bilaterally, pulseless, positive superficial abrasions to the right forearm. Dr. Scortibello, the medical examiner in this case who testified at length before the grand jury, described Mr. O'Keefe's right arm.
Alpha, I think I did see Sheridan's affidavit in this collection. I don't know which one it is though. Welcome, Raiders. Hope you guys are doing well. Appreciate it. Shout out to you, Biggin. We're just catching up on the Karen Reed case. Appreciate you guys.
Arm injuries as scratches caused by a blunt object. She described or noted that they appeared to be in a linear pattern. She detailed that she observed no signs of an altercation or fight from her thorough internal and external examination of Mr. O'Keefe. And lastly, she testified in great detail as to the swelling of his eyes being related to the fractures in his skull and how those manifested into the observable swelling and discoloration of his face. And essentially what she testified to was that there was a laceration on the right back of Mr. O'Keefe's head, that there was a skull fracture in that immediate area, the right parietal area of the victim's skull. That then caused a swelling on the brain, which she observed, as well as Dr. Stonebridge observed during her neuropathology examination of Mr. O'Keefe's brain post-mortem. That then caused the swelling underneath of the skull, caused the radiating skull fractures that she observed in Mr. O'Keefe's skull throughout. and that the essentially nowhere else for the blood to go, and the looseness of the vascular tissue behind the eye then causes both of the eyes to swell. There was no evidence that Mr. O'Keefe was beaten and left for dead. There was no evidence of any defensive wounds. She was specifically asked those questions and testified to that before the grand jury as to those injuries and how they sustained. There's absolutely no evidence that Mr. O'Keefe ever entered the residence at Fairview on that particular evening. Counsel mischaracterizes some other statements made by a witness, Mr. Brian Nagel, who had come to pick up his sister at the residence. She came out, he observed that vehicle. He observes that vehicle from the entirety of the time that he's there. So he's pulling on to Fairview. Ms. Reed is coming on to Fairview in the opposite direction. The right blinker on and a left blinker on. The operator of the vehicle that Mr. Nagel is in then essentially flashes its lights and allows Ms. Reed to pull in first. So Mr. Nagel is there the entire time that Ms. Reed pulls onto the street when she pulls up. Indicates that she initially pulls over to the right-hand side of the curb, then pulls the vehicle forward a little bit further. That's corroborated in testimony from a number of different people who were inside the house, as well as Mr. Nagel's sister, who then came out of the house and talked to her brother at the door of the truck that he was riding. Mr. Nagel further indicated that at no point did the brake lights come off, including the center top light of the SUV that he observed in front of the house. There were no footprints outside of the vehicle. He never saw anyone exit the vehicle. No one in the house reported ever having anyone come inside the house or seeing anyone exit the vehicle. And I'm a little confused just as far as counsel's statements, as far as the multiple people saw Mr. O'Keefe or never saw Mr. O'Keefe come into the house. Or if he comes into the house and he's attacked by the dog, I'm just a...
So I guess, so is this the area? They said near the, just before, this is 34 Fairview. There's the flagpole. And it's like, and they said they found the body like just before 34 Fairview. So like around, like, I guess here, well, near like this cluster of trees. So like around here.
A little confused as far as are they in the conspiracy, or are these people sort of let out of the conspiracy because they say something that doesn't further that conspiracy? If they're all in the house and Mr. O'Keefe comes in the house and gets attacked by a dog and then gets dragged out to the bottom of the lawn and left there for dead, then why do they all testify that no one came into the house? It's consistent throughout the entirety of all the witnesses. It's consistent with Mr. Nagel as well. It's consistent with the forensic evidence. It's consistent with every piece of evidence that has come to light at this point. And there's further statements in regard to the dog. Some reported incidents several months after the death of Mr. O'Keefe. The counsel suggests ineluctably that the animal was violent and prone to violence from one incident that postdates this particular time frame of Mr. O'Keefe's death, and seems to punctuate that this circumspection on and on about how violent the dog is from an incident that he has no information about, whether or not it involved another animal, whether or not it involved another human, whether or not it involved what exactly the incident occurred. This is simply not what Rule 17 is to be used for. That's what the case law has consistently held, is that it is not a discovery tool. It is based on information, relevant evidentiary support, which is completely and utterly lacking in this particular motion, in this particular submission. So for those reasons, the Commonwealth would request that the motion be denied.
Okay. So the second Rule 17 motion, are we going forward on that and then having the hearing regarding the timing of the video? How are we going forward with this before I hear from you on the substance, Mr. Jackson? What is the next date for?
Okay, yeah, right here.
What's it for? The evidentiary hearing?
Yes.
All right. So do you plan?
Yeah, so according to the trooper, when he first arrived on scene, and based on what the three of them were saying, the body was found around here, between the fire hydrant and the flagpole, and about 12 feet from the road.
And on arguing your Rule 17 motion today or that day? Not both?
That day.
Okay.
I'd rather reserve and
That
argue
makes sense
Rule
to
17 that day.
that makes sense to me as well. So we're finished for today, unless there was any follow-up to Mr. Lally. I'm
There
not
is.
going to hear a preview on the motion that we're going to hear on that day.
That's fine. I do have some points to make.
Okay,
and-
I'll hear you on that.
Thank you. With regard to the dog, first of all, I think the Commonwealth misses the point. If there was a fight inside the house with the dog's owner, the dog would likely attack. That is the idea that is borne out by the evidence that we have. We know that he was beaten. We've got evidence that John O'Keefe was beaten, that he lay there unconscious. And we also have evidence that at the time he was beaten, facially, and blunt force was used against the back of his head, he was also attacked by an animal. Well, Brian Albert, who's a known fighter, owns a 90-pound German Shepherd that has since been gotten rid of, and had a skin-piercing incident as the excuse for having gotten rid of him. So we know that the dog attacks, according to sort of uncontroverted evidence. We weren't saying, we don't suggest that the dog killed John O'Keefe.
So, according to Brian Albert's attorney's motion to oppose the Rule 17 against them, the skin-piercing incident was apparently that the German Shepherd got loose while Mrs. Albert was walking the dog and bit another pet. And that's what's documented, and they're saying that the reason why it was rehomed was because both Brian and Mrs. Albert were getting older, and it was harder for them to take care of the German Shepherd, so they had it rehomed. And apparently the dog is still alive, and the Alberts maintain contact with whoever currently is taking care of him now.
We're suggesting that the dog was there when John O'Keefe died and also attacked John O'Keefe. That's the point. This is the first I've heard of the Commonwealth's new position after, 15, 16 months, that somehow John O'Keefe was stabbed or cut up with a broken cocktail glass, which would produce these injuries. That makes absolutely no sense. It just doesn't pass the sniff test. These are not from a
Stank
cocktail
test.
glass. Who did that to him? Is there a new theory that Karen Reed got out of the car, broke a cocktail glass, then wielded an edge of that cocktail glass and cut up John's arm? Then John stood there while she jumps in the car, slams it into reverse, then hits him with the car, with her taillight in the back of the head. It makes absolutely no sense. That is the Commonwealth grasping at straws. If it walks like a duck and talks like a duck, it's a duck. This looks like an animal attack because it is an animal attack. And it's at the same time,
All right.
temporally, at the same time that he was otherwise beaten and then ultimately left for dead. Interestingly, it's interesting that the Commonwealth doesn't mention the basement in their arguments. I mentioned the basement because that's very likely exactly where John O'Keefe went once he walked into the house. There's no evidence that John O'Keefe walked into the house. The Commonwealth has evidence that John O'Keefe went into the house. They haven't. They just sat on it for several years, or for several months, over a year. That the Apple Health data from John O'Keefe's own phone establishes that once he was at the location at 34 Fairview, he climbed 3 sets of stairs. The Albert house happens to be 3 floors, a basement, a middle floor, and an upstairs. His Apple Health data also shows that he took multiple steps after he left the car, after he left Karen Reed's vehicle. The multiple steps indicate that he was in the house. If, in fact, the Commonwealth were correct, and he stepped out of the car, was hit by the car, and fell down and died, if that's what their theory is, he would have no Apple Health data suggesting that he was climbing stairs and walking about as if he were inside the house and was ushered down to the basement, at which point there was a fight.
Wait. Oh. Climbing stair. Okay, so is that what they're trying to explain from the GPS data of O'Keefe? That he was walking around that area? Because what Desert Sentinel sent me suggests that according to the GPS data, he is not inside the house at all.
He was beaten to unconsciousness, and then everybody in the house leaves, not having to go down to the basement.
Desert Sentinel, from what device in the GPS data that you sent me in DMs? From what device is that? Is that from O'Keefe's phone or his Apple Watch? Or wait a minute, am I confusing Apple Watch data with GPS data? I think that's what I'm confusing. So they're relying on the Apple Watch data, whereas the GPS data suggests that he was outside the whole time. But the Apple Watch is suggesting these elevation changes. Okay, so that might actually address one of my outstanding issues that I had.
There's a door that serves it's closed. So there's no reason for people who are upstairs, either upstairs or on the main floor of the house, to even know that there had been a fight downstairs, or that John O'Keefe never made it out of the house alive or conscious. With regard to Ryan Nagel, the Commonwealth leaves out probably the most important part of his testimony. Ryan Nagel's testimony is that he arrived just after Karen Reed arrived. They arrived not at the exact same time. She turned down the road. Then he turned down the road. As he approached the road, as he approached the house, he then pulls to a stop. He had her car in his sights the entire time, just after she had already arrived. Certainly time enough for John to get out of the car and walk toward the front door. He said that he observed that there was no taillight damage whatsoever. He later observed inside, either through a dome light or through other ambient light, that he could see inside the passenger compartment of her car, and that she sat there alone. And most important, he didn't see her hit anybody with her SUV. That's the most important part of Ryan Nagel's testimony. He didn't see her hit John with the car, which he would have had to have seen if he was situated right behind her. And the Commonwealth has repeated what they've oft repeated several times, which is there was no sign at all of any kind of an altercation or fight. Well, if there's no sign of an altercation or fight, how can he turn around and say that a cocktail glass did this? I mean, they can't talk out of both sides of their mouth. How could they reasonably ignore two black eyes, a laceration over his right eye, a laceration at his nose? He looked like he had gone 10 rounds with Mike Tyson, as my colleague has once analogized. Of course there's evidence that he was in a fight.
So this is also something that I was thinking about too. Again, I'm only looking at reading these motions as a layman. And I'm here, and in the medical examiner's report, in the description of the body, like he having two black eyes, and a lot of like severe bruises. On the one hand, yes, it sounds like on one hand it sounds like he could be hit by a car with those kinds of injuries. On the other hand, in my head, I think he's relying on the layman person thinking black eyes equals fight. I think that's what he's relying on too. Because most laymen only ever hear of black eyes or swollen eyes when they hear of somebody getting into a fight. not necessarily somebody getting into a car, getting hit by a car.
Back of his hands, deeply bruised. Those are called defensive wounds. I don't care what their medical examiner called it. Anybody who's seen any sort of a fight, a street fight, knows that the back of the hands, the back of the arms get the brunt of the punches as you cover your face. Of course there were signs of a fight. Not just a fight, a brutal fight. And what does a dog do when its owner is in a fight? What does a German Shepherd do when its owner is in a fight? Reaches out and attacks and supports his owner. And what does a person do when a dog attacks? Usually puts his arm up, his dominant arm up, to protect himself. And that's where the lacerations, the bite marks, the claw marks appear on John O'Keefe's arm. This is not a fishing expedition. The Commonwealth has an unreasonable expectation. They cite to words that we use what the evidence might show, or what it could show, what it potentially will show, as a weapon to say, well, see, they don't know what the records are going to show. Well, if I knew what the records are going to show, I already have the records. I wouldn't need the court to ask for them. Of course, I don't know everything that's in the records. And the reason that we asked, Your Honor, for 2015.
In fairness, I probably would be making that argument too if I was in his place. Well, you can't weaponize me about what may or may not show or what have you. If I knew what was going to be in the records, I wouldn't need them. In fairness, I'd be making it's not exactly the best argument, but they'd be the exact same arguments I'd be making too.
Is because we have evidence that in 2017 the dog looked full grown. So we wanted to go back and bracket the proper amount of time. If say the dog was a couple of years old at the time that photograph was taken in 2017, we want all the records associated with that dog, which means we bracketed our request. It's not overly burdensome. It's certainly not burdensome to the Canton Animal Control, and it's not burdensome to the Canton Town Clerk. And if the records don't exist, because they just don't, they're too old, then no harm, no foul. But that's why we bracketed our request to go back from 2015 to present. And with that, Your Honor, I believe that we have made a good faith showing. We have met the standards of Lampron, all four standards of Lampron, and the summonses should issue. And also.
So, So from what I recall from the medical examiner, from it was either the Commonwealth or the medical examiner's affidavit, is that what caused the black eyes, or what the cause of the black eyes, was that there was blunt force trauma at the back of the head, and that the trauma from the back of the head caused microfractures around the eye sockets, and it's those microfractures that cause the puffiness, that cause the black eye. I'm probably butchering it, but that's what I recall what the medical examiner said.
All right. Anything else, Mr. Lally?
Just briefly, Your Honor, as it pertains to, Commonwealth would agree that attributing the cuts on Mr. O'Keefe's arm in their entirety to cocktail blast would be somewhat ridiculous. That's not what I said, and that's not what I'm attributing them to. And I think the court understood that, but just so counsel understands that as well. As it pertains to Mr. Nagel, what is in his testimony is that he had the vehicle. They arrived at the residence in tandem. The vehicle was there when Mr. Nagel left.
Doc V, I have no idea what you just said, except for the raccoon eyes.
So while he sees no one exit the vehicle, no one enter the house, and no one else sees anyone exit the vehicle or enter the house,
I'd be going to Danny for advice on this.
The defendant, and presumably Mr. O'Keefe, are still there and still in the vehicle at the time Mr. Nagel leaves the house. That was the point that I was making with that. As it pertains to the Apple Health data, and obviously we'll get into this a little bit more when it comes to that subsequent Rule 17 motion, the Apple Health data is the same Apple Health data that's being relied upon for the supposition that Mr. O'Keefe went inside the house. That same Apple Health data has, among other things, Mr. O'Keefe taking 46 steps and traveling a certain bit of distance around 11:56 a.m. on January 29th. The problem with that is that he was pronounced deceased at the Good Samaritan Medical Center at 7:50 a.m., some 4 hours prior to that. In addition to that, from the
Oh, there,
information...
he just said it there. Oh, wait, he just said it. Hold on, let me reverse.
As far as was pronounced deceased at 6 a.m. on January 29th. The problem with that is that he was pronounced deceased at the Good Samaritan Medical Center at 7:50 a.m., some 4 hours prior to that. In addition to that, from the information as far as when that ascending or descending of stairs occurred between, I believe it's 12:21 and 12:24 a.m., there's a Waze search and location data from Mr. O'Keefe's phone. The Waze search is conducted, and the GPS location information from Mr. O'Keefe's phone shows him en route to the house and not arriving at the house until 12:24 a.m. So the information the council is relying on has him going up and down 3 flights of stairs before he's even at the house. So for those reasons, again, the Commonwealth would submit that the defendant has not met its burden and ask that the motion be denied. Before we do conclude, I just did want to remind the court there are a couple of other issues that I need to address with the court, specifically the Commonwealth's motions to impound and the Commonwealth's motion for access to the defendant's phone.
Okay, I'll hear you.
So there were 2 motions to impound that the Commonwealth had filed. One pertains to the grand jury transcripts and exhibits that I had attached as attachments or exhibits to the opposition to this specific motion, and really to both motions.
And those are impounded by statute.
Right. The other motion to impound that I had filed pertains to the attachments to the defendant.
Oh, there we go. I found what I was looking at. This is from the Commonwealth's opposition. The doctor also testified extensively to the injuries or swelling of the victim's eyes. Dr. Scorti-Bello testified that from her examination of the victim, both external and internal, that the bleeding and subsequent swelling around his eyes was related to the very small fractures in the skull. She testified specifically that, quote, the injury initiated or started in the back of the head, caused all the fractures in the skull, and then the eyes got red or black or purple because of the seepage of blood from the small blood vessels, end quote. The neuropathology report completed by Dr. Renee Stonebridge, also of the Office of the Chief Medical Examiner, attached hereto as Grand Jury Exhibit 27, are consistent with Dr. Scorti-Bello's findings.
It's Rule 17 motion pertaining to Mr. Albert's cell phone and the call detail records of Ms. McCabe and Mr. Albert. Now, certainly, the Commonwealth is not saying in any way, shape, or form that those items shouldn't be submitted. The defendant can submit whatever she wants, whatever counsel wants in support of that request for the court to review. But the manner in which the information is released, and specifically what I take issue with, and I'd be remiss if I didn't say this on behalf of the O'Keefe family.
I'm not sure they hear you.
In reference to the motion to impound the attachments to the defendant's Rule 17 motion for Mr. Albert's phone and the call detail records of Mr. Albert and Ms. McCabe, I'd be remiss if I didn't, on behalf of the O'Keefe family, as well as just what the statutory rules are, and specifically I'm talking about the Supreme Judicial Court, Rule 124, pertaining to protection of personal identifying information and publicly accessible court documents, which I would imagine that at least Mr. Unetti, even if Mr. Jackson and Ms. Little aren't familiar with, does provide rules as to how things are filed that are of that kind of sensitive nature and that kind of biographical.
Ooh, getting little broed. Little bro.
Filed with the court with a motion to impound or a motion to seal, and not filed directly with the media. The issue being that there are photographs depicting Mr. O'Keefe's postmortem at the Good Samaritan Medical Center, as well as possibly some autopsy photos that should have been impounded. There are unredacted Canton Police Department reports, multiple copies. Again, not anything that Commonwealth takes any issue with the court reviewing, but as far as them being made public with those witnesses' names, dates of birth, social security information, addresses, phone numbers, things of the like that should be impounded pursuant to the statute as well. And in particular, I do take issue with that motion, specifically on page 11. There is a specific reference made to the name of the decedent's niece, which is strictly prohibited as far as being provided in a public document. So for the
negating the boxer's fracture theory. Well, Alpha, did they ever allege that that O'Keefe? I know that they allege that O'Keefe was beaten up by Brian Albert. But did they ever make a comment as to whether or not O'Keefe was actively fighting, and therefore would have a hand injury? That's where I'm kind of confused by what you're saying here. I understand that part of their argument is that Brian Albert beat the hell out of O'Keefe, and the dog also had a round in too. But I don't know what else they were saying about whether or not O'Keefe sustained injuries as a result of fighting back or anything like that.
Those reasons, I would ask that the attachments to that motion, to whatever extent it can be at this point, given the public release of them, be impounded.
Mr. Yannetti?
Your Honor, I believe that some of that information may be in the public domain already, so it may be that the cat is out of the bag with regard to some of it.
It is now, right?
I'm sorry?
It is, the cat's out of the bag now.
Right, yes. So, I mean, we're agnostic on this motion to impound. You know, we have access to it, the Commonwealth has access to it, and most importantly, the court has access to it.
All right, so by statute, everything that was raised by the Commonwealth was supposed to have been
I see.
requested to be impounded at the time it was filed. So that was not done.
Are you talking about the motion that we filed with regard to the Albert phone motion?
Yes, the attachments. Mr. Lally just outlined it.
I don't think that there were any grand jury minutes attached to that motion.
No, that was a separate motion that Mr. Lally just
Right.
filed on behalf of his motion.
Right, and we don't have
when
a-
he was taking issue with the defendant had filed.
Right. Okay. Yeah, again, we don't have an objection at this point.
All right, Mr. Clerk, those are both allowed. All right, is the hearing, those are both allowed by statute. So is this hearing over?
Your Honor, if I could just address, the Commonwealth had filed some time ago a proposed procedure regarding communications stored in the defendant's iPhone. So we had addressed this briefly, I think, on the last court hearing date in February in relation to the defendant's phone. So the defendant's phone was seized lawfully from her pursuant to a search warrant. The information contained therein was then downloaded. Upon a cursory review of that information, there was an indication that there was some communication between Ms. Reed and Mr. Yannetti contained within the information within that phone. So obviously all examination of Ms. Reed's phone from the Commonwealth's perspective ceased at that time. And we had begun exploring and filing this motion. I had it in hand to file with the court on the last date. However, after several discussions with Mr. Yannetti and counsel for the defendant, I was then informed in court on the last date that the AFE or the independent sort of forensic examiner that would look at that phone was believed to have some sort of conflict. It was not acceptable to Mr. Yannetti. So there was a separate person who essentially runs the lab at the Attorney General's office, who I spoke to Mr. Yannetti about whether or not that person would be acceptable. He does have a conflict, just so the court is aware, as far as grew up in the same town as the victim and his siblings. But Mr. Yannetti indicated that he, at least verbally to me on that date, that he didn't see any issue with that conflict, as the person would just be assigning it to a couple different forensic examiners within his office. I then modified the motion to incorporate that subsequent AFE, sent a copy of the motion to counsel 6 weeks ago or so, and still have received no response. So what I'm looking for today is action on that. The other thing that I would note for the court is that counsel had asked for a raw extraction copy of the material from the defendant's phone, which was then provided to counsel on March 22nd. So for over a month, the defendant has had access to the defendant's phone and the Commonwealth has not, because counsel has failed to respond to whether or not the AFE was reliable or not. And what I was referencing on the last court date is the court had indicated that if we were to come to some sort of agreement, the court could act on the papers and obviate the need to address it on this date. It hasn't happened. I would submit that the proposed protocol was more than reasonable, and I would ask that it be allowed by the court.
So, Mr. Yannetti?
Yes. I was the one to suggest that it be analyzed by the Attorney General's Office, Cyber Crimes Division. I thought that was clearly, we have no objection to that, but I'll announce it in open court. We have no objection to that. The motion for the protocol, procedure is agreed to.
And you're okay with the individual that was cited in it?
Yes, the individual who was cited in it is the head of that unit. I know who he is. I respect him. He revealed to me at the start that he has a personal conflict. I have no issue with him assigning it to somebody in his office.
Okay. So the motion's allowed by agreement?
That's fine.
Okay.
Thank you.
Clerk? Motion's allowed by agreement.
Just one other thing. Mr. Lally had mentioned to me, and I don't know if he still intends to be heard on this, but there was an issue of exhaustive testing that I thought...
He argued that a while ago.
Okay, and was that acted upon by the court?
He said he was waiting to hear back from you where we stood on that.
Right, so with regard to that, Judge, we're all for exhaustive testing as long as we can have our expert present at the time.
So, Mr. Lally, would you say again what you explained to me?
Certainly, Your Honor. So there's a form that's provided by the lab that I then provide to counsel. In this case, in any case, that where exhaustive testing is necessary and the sample would be subsumed within the analysis. So I provided that to counsel. I just simply need counsel to execute that form, indicate whether or not they want someone present and who that person is and what their contact information is, and then I'll provide it to the lab. The lab will then contact their expert and schedule a time for the testing to be done.
Okay, we're happy to do that, but my understanding from Mr. Lally's earlier argument is that only applies to the hair that was found on the car that was not part of any motion that we had today in terms of a motion to compel. What about the other evidence with regard to the tissue samples and everything else that we actually asked for in our motions today?
Is there exhaustive testing on any of those items, Mr.
Not that
Lally?
I'm aware of.
Okay, fine. Yeah, so we'll sign regarding the hair. We're not concerned about the hair.
Okay, is that everything?
From the Commonwealth, yes.
I believe so, Judge. Thank you.
All right, thank you. We'll see you on the 25th.
5:25 at 9:30, correct? 9:30. Thank you.
All right. Hearings from September of, well, I'm starting from the hearings from May of this year, Amy, so that's where I'm going. This is from May. What's the next one? This is from 7 months ago.
That are highly relevant.
So May 24th.
And highly material to our production of evidence in furtherance of a third-party culpability defense to which Ms. Reed is richly entitled. Your Honor, our request is not a discovery request. Our request is an evidentiary request. That's very different. We are not asking for discovery through the process of seeking Mr. Albert's phone or the phone.
Okay, so this is the one I actually really do care about, and this is one for Brian Albert's phone information.
Phone records associated with Ms. McKay. We're asking for evidence. Evidence that's material, evidence that's relevant, evidence that's...
But it sounds like this started like in the video starts in the middle of the hearing. I want to hear the full one, because I don't want to miss anything. Seven months ago, so is it May 24th? This is it, though, actually. Karen Reed. Hearing May 24. Shoot, this is it. Yeah, this is the only video. This is the only recording. All right.
that are highly relevant and highly material to our production of evidence in furtherance of a third-party culpability defense to which Ms. Reed is richly entitled. Your Honor, our request is not a discovery request. Our request is an evidentiary request. That's very different. We are not asking for discovery through the process of seeking Mr. Albert's phone or the phone records associated with Ms. McCabe. We're asking for evidence. Evidence that's material, evidence that's relevant, evidence that's salient to a third-party culpability defense, one that we've already made a good faith showing exists in this case, and this court has already ruled is a relevant and material defense. We ask that the court issue the summonses under Rule 17 for both Mr. Albert's phone and the associated data therewith, as well as Jennifer McCabe's cell phone records and the associated data therewith.
All right. Thank you very much. Mr. Lally, I'll hear from you, but am I also going to hear from Mr. Albert's lawyer, and am I going to hear from Ms. McCabe's lawyer as well? We'll call on you afterwards. I'm going to hear from Mr. Lally first.
Thank you, Your Honor.
All right,
Your Honor,
here we go.
Commonwealth requests that
Your Honor, I'm sorry to interrupt. If Mr. Lally, or if the court could gently ask Mr. Lally to address the court from the podium.
Oh,
I
sure.
simply can't hear
Can
him
you go over there?
with his back turned.
No, absolutely.
I'm going to ask you to keep your voice up so I can hear you over here from there, please.
Understood. So, Your Honor, the Commonwealth requests that the defendant's Rule 17 motion be denied. This isn't a situation where the Commonwealth is afraid of evidence being produced or desperately afraid, as I believe as it was just characterized. It's simply that counsel and the defendant need to comply with the rules and need to actually state actual facts and actual evidence, as opposed to the fanciful facts section that's been submitted to the court. This case does not, as counsel suggests or states pretty plainly, hinge solely upon the testimony of Ms. McCabe. The statements and testimony of other witnesses, the forensic evidence, the video evidence are conjunctively simply hard to reconcile with counsel's facts, even assuming everything appeared in their motions and affidavit is true and accurate.
Oh my God, hold on. Oh, this beef jerky that Doug sent me is so good, yet so spicy. Oh, it hurts so good. Oh, it hurts so good. Oh God, I need water. Oh. Okay, I'm back.
Which I submit that it's not. The predominant amount of statements made by the defendant to this witness, being Ms. McCabe, were made by the defendant in the presence of additional witnesses, which is conspicuously absent from counsel's recitation of those facts. Counsel states in the motion that the defendant, quote-unquote, has always maintained the purported story of her leaving Mr. O'Keefe at the Fairview residence and calling him repeatedly to ensure that he was safely within the home. The defendant, over the course of the investigation, said a lot of things to a lot of people. She talked to a lot of civilians. She talked to a number of troopers involved in the investigation. This story was never presented, not once. She did present varying accounts to varying people as far as when she last saw Mr. O'Keefe, what happened with Mr. O'Keefe the last time that she saw him, but never this particular version of events. The defendant seems to suggest that the body of Mr. O'Keefe was discovered that morning by the defendant and Ms. McCabe. However, Ms. Roberts was present with him at this time as well, but remains absent from counsel's recitation of the facts. Counsel further states that Ms. McCabe, quote-unquote, inserted herself into the defendant's search that morning for Mr. O'Keefe. However, it was the defendant that awoke the victim's niece at approximately 4:30 in the morning, had the niece repeatedly call and text Mr. O'Keefe, and then asked or instructed the niece to call Ms. McCabe at 4:53 in the morning. So this suggestion that Ms. McCabe is up all night pacing around her bedroom, or that she's shockingly awake at 4:53 in the morning and answers this call from the defendant, She answers the call from the victim's niece, and then the victim's niece, at the instruction of the defendant, puts the defendant on the phone. And that is how this search or how this issue begins. The defendant initially tells Ms. McCabe that she last saw the victim at the waterfall. When she's then subsequently informed by Ms. McCabe that she had seen, being Ms. McCabe, had seen Mr. O'Keefe and the defendant leaving the waterfall together, and further seen the defendant's vehicle in front of the residence on Fairview, the defendant then indicates that she left Mr. O'Keefe on Fairview after they had gotten into an argument. These aren't just statements that Ms. McCabe testified to. These are statements that the niece overheard while Ms. Reed was talking to Ms. McCabe on the phone. She provided an interview, a sane interview, due to her age, and indicated and corroborated those statements Ms. McCabe attributed to the defendant. The delay that counsel averres in the motion that Ms. McCabe caused in Ms. Reed's frantic search or trying to get to the residence on Fairview, the evidence demonstrates from Mr. O'Keefe's ring video that the defendant left Mr. O'Keefe's driveway at approximately 5:08 in the morning from the ring camera. She does not arrive for approximately half an hour later at Ms. McCabe's home. And the information from her phone and the information from the video from the Canton Public Library and from the Temple indicates that during that time frame she travels towards the waterfall. She travels in the direction of the Fairview residence. So any delay that was caused in her getting to that residence with Ms. McCabe and Ms. Roberts was her own doing and not that of Ms. McCabe. Now, the defendant also states that Ms. McCabe stated to Trooper Proctor that while they were searching for Mr. O'Keefe, the defendant repeatedly asked, "Could I have hit him? Did I hit him?" The defendant also repeated these statements when the body of the victim was discovered, as reflected in the testimony of Ms. McCabe. It's also reflected in the testimony of Ms. Roberts. It's also reflected in the testimony of the first responders, paramedic.
Mandy, were you away when I made the statement about the Reed supporters in the chat?
Standing.
I was, but I'm reading it now.
Yeah. Okay. Gotcha.
So I got it. Yeah.
Next to the defendant when she said these things in response to the paramedics' questions. The further statements that Ms. McCabe attributes to the defendant while they're driving around were also corroborated by Ms. Roberts because Ms. Roberts is on the phone with them.
Yeah. If you're Veronica, if you're referring to Rule 17, the thing is, Rule 17 is a Massachusetts specific rule, evidentiary rule that I'm not familiar with. There are 4 prongs that to satisfy the burden. Well, I'll let you know. A defendant seeking pretrial production pursuant to Rule 17 must make a demonstration of relevance, admissibility, necessity, and specificity in order to sustain her burden. To satisfy the burden, defendant must show that the documents are evidentiary and relevant, that they are not otherwise procurable reasonably in advance of trial by exercise of due diligence, that the party cannot properly prepare trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial, and 4, that the application is made in good faith and not intended as a general fishing expedition. So those are the 4 prongs that need to be done. My understanding is that the Commonwealth is going to argue that they fail prongs 1 and likely prongs 4, that they're not evidentiary and relevant, and that the application is not made in good faith and not not a general fishing expedition.
Bluetooth, while Ms. Roberts is driving her vehicle and Ms. McCabe is driving Ms. Reed's vehicle from Ms. McCabe's house back to Mr. O'Keefe's house. So all of these statements that Ms. McCabe has purported to have created are corroborated by other witnesses, by video, and by forensic evidence. The new revelations or the new evidence that counsel veers was withheld from the defense that Mr. Green has apparently uncovered is specious at best. It's from the affidavits or the reports that were subsequently done by Trooper Garino and an independent forensic experts that our office hired in regard to this, whose qualifications are contained within the attachment that I filed with the court, approximately a 21-page resume that she has in this particular field. She teaches in this field, she writes in this field, and she comes to the same conclusion that Trooper Garino does, that those Google searches that are attributed by Mr. Green as happening at 2:27 and 40 seconds in the morning did not occur at that time. They were a result of the file being parsed from a write-ahead log or a wall file.
Okay, actually, okay, this is actually all right, I'm going to say it right here. This alleged search engine search that the defense's forensics analyst said that McCabe allegedly did a search for how long to survive in the cold at 2:27 a.m. This is one of the issues that I'm curious about, and that seems a little bit sussy baka. So the Commonwealth is going to provide the explanation, and that's actually one of the things I've been curious about, because I haven't been able to see what kind of explanation has been made about McCabe supposedly making this search at 2:27 a.m. the night of the murder. So I don't. So hold on. Let me reverse it a couple bits, and I want to hear this.
And she comes to the same conclusion that Trooper Garino does, that those Google searches that are attributed by Mr. Other witnesses by video and by forensic evidence. The new revelations or the new evidence that counsel veers was withheld from the defense that Mr. Green has apparently uncovered is specious at best.
Mr. Green is the defense's forensic analyst.
It's from the affidavits or the reports that were subsequently done by Trooper Garino and an independent forensic experts that our office hired in regard to this, whose qualifications are contained within the attachment that I filed with the court, approximately a 21-page resume that she has in this particular field. She teaches in this field, she writes in this field, and she comes to the same conclusion that Trooper Garino does, that those Google searches that are attributed by Mr. Green as happening at 2:27 and 40 seconds in the morning did not occur at that time. They were a result of the file being parsed from a write-ahead log or a wall file. The analogy that I would make as far as Mr. Green's analysis of the phone is very similar to counsel's recitation of the facts. It shows you one thing, but neglects to put it in the context of the rest of the facts. Neglects to put it in the context of the remainder of the evidence. And what Mr. Green does is, yes, there is an indication in the phone that there was a search at 2:27 and 40 seconds in the morning. However, if you look behind that data as to when that entry was actually created, it's 6:23 a.m. and 6:24 a.m., which is while Ms. McCabe is on the scene in front of the Fairview residence with the defendant.
Wait, hold on a second. Hold on. Wait, what does he mean by that? I'm actually confused. Hold on. What does he mean by that?
Ms. McCabe, it's 6:23 a.m. and as in the context of the rest of the facts. Neglects to put it in the context of the remainder of the evidence. And what Mr. Green does is, yes, there is an indication in the phone that there was a search at 2:27 and 40 seconds in the morning. However, if you look behind that data as to when that entry was actually created, it's 6:23 a.m. and 6:24 a.m., which is while Ms. McCabe is on.
What does he mean by behind that data, though? Awesome, Amanda. Thank you for the $2.99 Australian. What I want to know is, what does he mean by if you look behind that data?
On the scene in front of the Fairview residence with the defendant conducting that Google search in response to the defendant's request to conduct that Google search, or to Google hypothermia or something to that effect. As far as these deletions within the phone,
is the data referring to the ping time? Akira 808 Stay, thank you so much for the 33 months. Look in Discord. Oh my god, this is... Uh-oh. What? Bro, this might as well be Japanese to me. I might have to, well, I'm also kind of like half cocked. So, I might have to look at this sober. Ha, nice one, Deadpool. Client versus, I understand where you're saying, Paul, client versus server time. I do understand that. I'm trying, let me find Green's affidavit. Where's Green's affidavit? Uh-oh. Ah, here we go. Found it. Oh. All right. Using the tools outlined. Use the Celebrite Physical Analyzer, an Axiom Forensics 6.11, using Belkasoft X, Sanderson, SQ, Light Forensics Explorer, Cellhawk by Hawk Analytics. All times have been converted to Canon MA local time, UTC 5, UTT -5, unless otherwise noted. Search term, house long to die in cold, date time 1/29/2022, 2:27:40 a.m. URL, source, Safari suspended state tab. Deleted as reported by Celebrite. Attached here to is USF1. And then, okay, there. Location, private, var mobile library, Safari browser state.db-wall. Time converted to UTC. Saturday, 7:27:40 a.m. Adjusted to local time. 2:27 UTC -5. It was deleted. Browser state is information about the open tabs in Safari application allows the user to leave the application or return at a later date. Individual tabs can be deleted by the user. Here, Celebrate indicates that the 2:27 a.m. search for how long the died in cold is deleted by the user. Also perform timeline validation. The timeline validation 2:27 a.m. search by confirming that the device was used at the time of the search. Following artifacts support that the user was interacting with the phone during this period. The phone was unlocked between 2:23 2:31. Text messages were sent 2:25 2:25. Screenshots were deleted at 2:26. The search was entered at 2:27. Unequivocally established an individual using the phone. 11. Search for how long to 2:27 on January 29, 2022. She conducted several searches on that morning at 1:29, 6:23, and 6:24. Yeah. Okay. Yes, I might be a little bit too. Shut up. You guys suck. So the problem. And then looking at this browser state, maybe last visited time. But this is way beyond me because I own a superior Samsung Galaxy device and not a godforsaken iPhone. So this Apple iOS jargon is Greek to me. So I'm gonna have to look at that later when I'm more lucid. All right.
I forgive you.
Oh my God. iPhone cut.
Both forensic experts, being Trooper Garino and Ms. High, indicate that these deletions are not something that is actively done by the user. So to simply say, oh, this information was deleted from the phone is not an indication that Ms. McCabe deleted that information from the phone. It's something that happens as data is stored, as data is set aside. To such things as this wall file. There is a search at 2:27 and 40 seconds in the morning, and it's in relation to Ozone basketball. Now, Ms. McCabe also testified that the night before going to the waterfall, her and her husband had gone to one of her daughter's high school basketball games. She indicated that her girls play basketball, girls play sports. She's checking scores, she's checking standings, she's checking stories about her child's basketball game at 2:27 in the morning. And essentially, the best way that I can describe it is this. If you were to open up the Safari app on your cell phone, and you engage the Google website and you do a Google search, then you close that Safari tab, the Safari application, you put the phone down on the desk for 6 hours. You pick up the phone again after that time has elapsed. You go back to the same Safari tab, and you go back without creating a new tab or a new website, you go back and do a subsequent Google search. That subsequent Google search that you're doing at, say, 6 p.m. is going to reflect in the phone as being done when the website was first visited, when Google was first visited, that's 6 hours before. That is what happened in this particular case, and it's borne out throughout the affidavits and reports from the various forensic experts in relation to that. Now, as far as the phone calls to the Alberts from in front of the house, yes, there are phone calls reflected in the phone. There is no deletion of Mr. Brian Albert's contact information from within the phone. It's still in the phone. It was in the phone when Trooper Garino did the extraction on May 4th of 2022. It's still in the phone now. The phone calls, I think, are perfectly sort of understandable in the sense that Ms. McCabe is in front of her sister's home, finds her friend lying on his back, struggling for his life, and she makes a phone call to her sister. The phone call's duration...
I know, Persnickety, shut up.
But so do calls when they go to voicemail. They list in the phone as answered. And the duration of the calls, I think, is telling. And that the first call at 6:07 and 42 seconds lasts for a duration of 9 seconds. The second call at 6:08 and 17 seconds, which also lists as answered, lasts for a duration of 7 seconds. These are calls that are going to voicemail. And then subsequent to that, at 6:23, Ms. McCabe makes a phone call to Brian Albert, which lists as unanswered. The last, as far as the health data, I don't want to keep reiterating this. I spoke about it in the last court date, but the health data for Mr. O'Keefe's phone has him taking 133 steps at 8:08 in the morning, 68 steps at 8:25 in the morning, 87 steps at 7:57 in the morning, 81 steps at 11:06 in the morning, 109 steps at 11:18 in the morning, and then 46 steps at 11:56 in the morning. The issue with that, as far as being able to rely on any of that data for anything whatsoever, is that Mr. O'Keefe was pronounced deceased at the Good Samaritan Hospital at 7:50 in the morning. So all of these steps, all of these feet, all of these things that he is traveling are after he has passed away. Furthermore, as far as the 3 floors going up and down within the house, in Trooper Guarino's report, he details as far as looking a little bit deeper, a little bit more than just, oh, the phone or the health data indicates that he went up or down 3 flights of stairs. What it also indicates from Mr. O'Keefe's phone, from the GPS information, is that he did a Waze search because he had never been to 34 Fairview Road before. He does a Waze search to try to locate it. Now, that GPS information from his phone has, at the same time that he's going up and down 3 flights of stairs, he's more than a half mile away from the residence at that particular time. It also gives speed. He's traveling at a certain distance, meters per second, that's encapsulated within Trooper Guarino's report as well. None of that health data is even remotely accurate. Now, furthermore, there is a supplemental report, which I filed as an attachment to the Commonwealth's opposition that Trooper Guarino conducted in regard to certain measurements and GPS locations from Mr. O'Keefe's phone. And what they show is sort of concentric circles as far as the distance that the person could have traveled from that in those specific time frames. And essentially what it boils down to is there is a total of 3 seconds. 3 seconds in the entire time that Mr. O'Keefe is in the area of 34 Fairview Road that any of those concentric circles even touch the house of 34 Fairview Road. And following immediately from those 3 seconds, the circles are able to then be condensed and more accurate information is generated in relation to putting him exactly where he was found at 6 o'clock the next morning by Ms. McCabe, the defendant, and Ms. Roberts. And again, another statement attributed to Ms. McCabe is that Ms. Reed was the only one who could see in the blizzard conditions, which I know the court has reviewed in relation to Officer Sharaf's cruiser camera footage of his approach and arrival at the scene, which is almost around the same time as the 3 ladies would have been approaching 34 Fairview. But the point being, again, it's a statement that Ms. McCabe is, the only one who said that the defendant said this, or the only one who describes this reaction by the defendant as being the only one who could see Mr. O'Keefe laying in the snow, covered in snow from that distance in the dark in a blizzard. But unlike in the recitation of counsel's facts, Ms. Roberts, who was in the vehicle, says the exact same thing as Ms. McCabe. And I think one of the other things to note is that these 2 women, as far as Ms. McCabe and Ms. Roberts, essentially barely know each other at this particular point. So how they are related to this case and how they are related to Mr. O'Keefe is Mr. O'Keefe cared for his niece and his nephew. Now, Ms. Roberts has a son around the same age as Mr. O'Keefe's nephew. They both Ms. Roberts and Mr. O'Keefe grew up in Braintree, knew each other in that regard. Now, Ms. McCabe has a daughter and lived in the general vicinity initially where Mr. O'Keefe lived when he took over care of those children. And his niece is around the same age as one of Ms. McCabe's daughters. Different ages, different genders, different kids. They barely knew each other before this day. And now they're sort of inextricably linked going forward based on their shared experience of being called and told different stories by the defendant on this particular day and taken on this ride along to discover Mr. O'Keefe's body. What I would say, Your Honor, is the revelations from the forensic expert from Mr. Green, which is the only thing even closely approximating new information from the prior Rule 17 motion that was denied in relation to this, they're specious at best. None of that information, based on the further, it's similar to the arguments that are made in relation to the facts by counsel. If you take one piece of evidence, you divorce it from context, and you don't provide any sort of contextualization of what that means within the whole of some of its parts. And the same thing is being done as far as the affidavit from the forensic expert is taking this thing and saying, oh, well, there's a search and it's deleted. But if you look at the search and you look at what deleted means, it doesn't mean what counsel says it means. It doesn't mean what counsel purports it to be. And for those reasons, I would ask that the motion be denied.
All right. We'll hear from Mr. Mr. Albert's counsel first, and I'm going to let you speak again, Mr. Jackson.
Thank you, Your Honor. So you've heard for 40-something minutes different recitations of facts. I want to focus for a moment for the Rule 17 just on my client and the allegations that the defense has made. Even after you bottle up everything that's been said, the allegation is that someone, not my client, placed a phone call.
Well, the thing is, Woodwork asks, forgive me if this sounds dumb. But in this case, is this case all based on circumstantial evidence? It isn't cut and dried. Well, here's the first thing I learned in law school, Woodwork, is that the vast majority of cases are the vast majority of guilty verdicts are done with circumstantial evidence. There's two kinds of evidence: circumstantial and direct. And the thing is like, unless you have photographic evidence or video or witness testimony, all other evidence is circumstantial. DNA matching is circumstantial evidence. And the thing is that circumstantial evidence, depending on the type, can be very, very, very strong. And direct evidence, such as witness testimony, can be very, very weak. As a matter of fact, that was also one thing I learned in law school, is that witnesses, people don't realize that people have some of the shoddiest memory on this earth. And witness testimony can be extremely weak, depending on the facts and circumstances of the case. So, and that's direct evidence. So do not rely on whether or not the majority of the case is reliant upon circumstantial evidence. Fingerprint evidence is also circumstantial.
To my client that went unanswered after the body had been discovered in the front of the house. That's the sum total of the allegations from defense that touch on the issue of the phone. The rest of the material that the defense has suggested is relevant to their Rule 17 is theory, and I would argue it's the alternate theory, and they're entitled to make their alternate theory argument. Mr. Jackson a few moments ago used the phrase safe harbor in relation to the concept of fishing expedition, and he actually stole the words that I was going to use in relation to the concept of third-party culprit. Because really what that boils down to here is the defense is saying we get to do whatever we want, search high and low, do whatever we need to in order to defend our client. And I understand in concept what that means. But the issue is that under the provisions of our law and the case law, they can't just say it's relevant to their case, snap their fingers, and then go into the personal effects of a third party person who's related to the case only because they're a witness. But that's the argument that they're making. The only connection between what they're suggesting and my client's phone is an unanswered phone call. Unanswered at 6:23. Counsel made the suggestion that I said earlier that there's never any indication or no record of a phone communication. That's not what I said in my opposition. I said there's no indication of a conversation because there's zero grand jury testimony about it, there's zero forensic evidence about it, there is no conversation because one didn't take place. But that's the suggestion they're using to then bootstrap the rest of the argument. The federal Rule 17, the equivalent, is guiding Massachusetts case law. That's been referenced in Lampron Inquiry. There's a federal case that came out in 2018. I provided a copy to counsel and I provided it to the Commonwealth, and I'll hand up a copy to the court. It's, in essence, it's United States versus Cartagena Albadalejo, 299 F sub 3rd 378. And in this case, there is a Rule 17 subpoena that is issued by the defense seeking, quote, exact copies of the reports, photos, or notes regarding a shooting incident on a particular date. And in this particular case, the court made the comment in ruling against the Rule 17 decision that
whoever's in my Twitch chat, yes, you can use emotes and spam the screen with emotes on Twitch chat. You got to be on Twitch, though.
Just for copies of notes and photos or reports was overly broad. quote, the potential to bolster a complainant's allegations and the potential to undermine them, provide possible material for impeachment, but the inability to articulate with precision what records he seeks or the purpose for which he seeks them confirms that he cannot satisfy the specificity problem. If the moving party cannot reasonably specify the information contained or believed to be contained in the document sought, but merely, quote, hopes that something useful will turn up, this is a sure sign that the subpoena is being misused. Moreover, they have cited no authority to support the proposition that searching for, quote, alternate theories is a proper basis to compel production of documents. And that is precisely what we're dealing with here. The defense has a theory. I give them that. That's their job. But the Rule 17 standard does not allow that they snap their fingers, come up with a theory, and then intrude on other people's personal, private materials in order to then build their case. Because the concept there would mean that, again, we're talking about one phone call, so let's use this in some other case, because if the court were going to make this ruling, it would stand for a proposition. The proposition would be that if a witness to statements and a witness to conduct of the defendant makes a phone call, any phone call, the person that that witness contacts has to turn their phone over to the defense if they want to create an alternate theory of the case. And that cannot be what Rule 17 stands for. This case, the federal rules, the state rules, they outline the standard that the defense needs to meet. And if you look at the actual Rule 17 that they filed, what they're requesting is far more broad than, quote, reports, photos, or notes. They're requesting a 7-day period of everything having to do with the phone and the phone itself. That overly broad interpretation of Rule 17 is reflective of what the defense theory is here. The defense theory is we have an alternate defense. We want to argue and create evidence for that alternate defense. And that is not what Rule 17 is designed for. Because Rule 17 isn't about her. Rule 17 is about the third parties. It's designed to protect those people who, by no fault of their own and no conduct of their own, become involved in a matter, either as a witness or a bystander or what have you. That's exactly what's happened in this case. And so rather than trying to meet the burden, after hundreds of pages of affidavit and supporting documents, what it boils down to is a phone call that was placed and never answered and no communication. And they're trying to use that plus all of the other window dressing to suggest that that allows the court to order a subpoena for a third party to turn over their personal effects. And that is not what Rule 17 stands for. I just ask that the court take this into consideration, even though it's not part of the opposition memo.
No, I'll take a copy of that. Thank you. Thanks, Jen. All right, Mr. Jackson, I'll let you respond. After that, Mr. Reddington, if there's anything you want to say, I'll let you say it. Thank you very much. All right, Mr. Jackson, so go ahead and I'll hear you.
Thank you, Your Honor. With regard to the Commonwealth's argument, taking those in order, to reuse the same word that's been used and probably beaten to a pulp today, talk about a regurgitation of the same tired, factually incorrect theory. That's exactly what you heard today, was exactly what Mr. Lally has been reciting. He literally read it from a paper that he's clearly had for some time. It's the exact recitation of the same facts that he's used over and over and over, and they are factually incorrect. He indicates none of the facts that we've cited in our moving papers are supported by any evidence. That's absolutely incorrect. That's absolutely incorrect. For instance, Jennifer McCabe. He said Jennifer McCabe was not up all night. There's no evidence whatsoever that Jennifer McCabe was up all night, except for her Apple Health data, which shows that she was up all night. We didn't make that data up. That data came right from a cell phone extraction that was conducted in no small part by their own expert, and then reconducted by our own expert. How about the fact that she was actually on the phone searching? The Safari data establishes that not only was she up all night, but that the phone and Safari was being manipulated during those times at 2 o'clock, 3 o'clock in the morning. These are unassailable facts, unassailable data, directly from the Celebrite extraction These aren't, as Mr. Lally likes to say, fanciful facts. He's got that written down somewhere, obviously. He said that at just about every hearing. There's nothing fanciful about any of the facts that we've submitted and have supported with affidavits and evidence. The Commonwealth's theory, quite to the converse, is supported by nearly nothing. Nothing. Everything that we've suggested is supported by the data, the evidence, and the facts. The Commonwealth's theory is supported by conjecture and really bad policing.
Really? Okay.
Almost unbelievably and very troubling as an officer of the court, Mr. Lally provides a brand spanking new expert yesterday. We didn't have any of the information concerning this new expert. Quite frankly, I haven't even committed her name to memory yet. I don't even know it. It's Jessica Hyde, Hyde. First time I've ever heard of Jessica Hyde was yesterday while I was on the plane on my way here. That's when we received that information. And lo and behold, Mr. Lally springs that on us today and starts reciting her factual conclusions and opinions. That is wildly inappropriate, wildly unfair. We haven't had an opportunity to look at her report.
Welcome, Heidi.
Review it in detail, to have our expert compare his notes to her report. What I will tell you is that what Mr. Lally said about her report is not quite true. He didn't quite get that right either. What she actually said is why the timestamp is listing the time of 2:27 and 40 seconds in the morning is unknown. Her words, not my words. That's what she said about the timestamp. That her conclusion is the reason for the definitive timestamp is unknown to her.
Welcome.
Well, we know
another raid. Wow. 2 raids in one night. I feel special. Thank you. Welcome, everybody. Yeah, we're just watching. I'm just trying to catch myself up, learn about this case since I was invited into this hellhole / rabbit hole of this Karen Reed case by my viewers, and yeah, I'm being dragged in. We're either at the 7th or 6th circle at this point.
Why it is, because we've had more time to distill it. There's something, and I'll take this opportunity since Mr. Lally brought it up and tried to explain what his theory, an incorrect theory of the timestamp is. I'll take a minute to explain what the actual true facts are. An Apple iPhone has a clock in it. It's an internal. It actually has 2 internal clocks. One of those internal clocks is run by a program known as Apple COCOA Core Time. The Apple Cocoa Core Time is the number of seconds from January 1st, 2001 until right now. So for instance, if I open my phone, which I just did, Apple Cocoa Core timestamp just noted the exact moment that I just opened my phone. And it's noted from January 1st, 2001. Right now, actually in 2022, in January of 2022, those numbers of seconds was around 665 million. About 665 million seconds had passed between January 1st at midnight, 2001, to January 29th, around midnight, around 2:27 in the morning, on January 29th, 2022. Why is that important? Because their expert, Mr. Guarino, indicated, oh, well, you can't rely on the timestamp of how long to die in coal, because that's at the exact same time as the Ozark basketball webpage was brought up. So something must have gone wrong. I don't really know what it was, but it must have been something. Well, what we would do, had we had an opportunity to cross-examine Mr. Guarino, is perhaps explain to him that which he doesn't know, which is the following. More than one web page can be up and open on a cell phone at any given time. The court knows this. Everybody who owns a cell phone knows this. You can have multiple pages open. One page is sitting on top of the other, and then there are multiple pages behind it.
What's the idiot droning on about. The defense counsel's art is talking about the timestamp. That's a point of contention in terms of Ms. McCabe's phone. The whole the smoking gun, as it were, is the alleged Google search of how long to die in cold was done at according to defense counsel's forensic expert, was timestamp at 2:27 a.m. According to his forensic software or what have you. And that's what the argument he's making. The Commonwealth is saying that there's that on the back end that the timestamp is inaccurate, and in fact that the how long to die in cold is actually reflective of the actual time of the search, which was at 6:27 a.m. The morning of the incident itself. I don't know. So I'm kind of confused by the Commonwealth's explanation by it, but I know a lot of people have been throwing me blog posts and explanations. I'm not disputing. I'm not like discounting the explanations. This is like I'm a little bit too inebriated to fully understand it, so I'm gonna have to wait until I sober up in the next morning to kind of read through it and understand what's going on when it comes to the timestamping. But that's what the defense counsel is arguing right now.
All those pages are still open and running in the program in the iPhone. The 227 how long to die in cold search was nanoseconds, milliseconds before the Ozark basketball search page came up. How did Apple Cocoa Core Time relate those two events, those two artifacts on the phone? It happened like this. At some point, she searched, used her thumbs. The Apple iPhone doesn't coordinate the timestamp for when she's using her thumbs. People type faster, people type slower. It coordinates when someone exits out of a search. In other words, when you close that web page. She obviously Google searched how long to die in cold. We know that because we found the search. The deletion was not the deletion of the search, it was the deletion of the page. And as soon as that page was deleted, the other page behind it, Ozark Basketball, was immediately populated. And when I say immediately, not at the same time, nanoseconds behind it. We actually have the nanoseconds. It's 5 digits beyond the decimal point. We know exactly how that happened and why it happened. And Rick Green, our expert, has verified that, not through one, not through two, but 5 different tools.
Is he suggesting that Brian, Ms. McCabe did two separate searches nanoseconds apart?
Establishing exactly how long that it took for the Ozark page to populate behind the how long to die in cold page once Jennifer McCabe exited out of that page, if that makes sense. So we know that she was Googling how long to die in cold at minimum, 3 hours before John O'Keefe's body was ever found. This is not some anomaly. It's not a question. It's not, as their new expert says, unknown why the Google search took place or the timestamp is what it is at 2:27:40. We actually know. Rick Green knows. His colleagues know. And the scientific community knows. Mr. Lally also said Jennifer McCabe...
Oh, Colin, thank you for the raid. Sorry, Mandy. I'm sorry for the all... Thank you for the all caps DM. Thank you very much, Colin, for the raid. I much appreciate it.
This stuff just happens. Well, stuff just doesn't delete itself on an iPhone. Everybody that has an iPhone, every 4-year-old that has an iPhone knows that stuff doesn't just delete itself. That's not how iPhones work. Everything that was deleted was concentrated into a time period. It was concentrated on or around January 29th, 2022, at or around 6 a.m., 7 a.m., 8 a.m., throughout the day, on the 29th, and up until she turned that phone in on February 2nd, 4 days later. Those deletions weren't coincidental. They were done by her. 18 separate calls were deleted. There were 7, by the way, and I will address counsel's statements about Brian Albert and his phone in just a second, but it dovetails into what I'm saying right now. In terms of the conversations that counsel talks about, what he said was there was no conversation between Brian Albert and Jen McCabe on the 28th or the 29th. He's just wrong about that. Just ignoring the facts.
Happy weekend, Robert.
Calls. One of them, at 6:24 a.m., was unanswered. The other 6 were all answered. And there were conversations. They were, in some cases, not just seconds, but minutes long. So there is evidence that McCabe and Albert were communicating back and forth to one another. That's why it's important that we verify what those communications were and how long they took, and what other communications might exist on Brian Albert's phone that weren't sanitized by Jennifer McCabe before she turned her phone into the authorities. There were also phone calls, not to Brian Albert, but to Nicole Albert at 6:07 and 6:08 in the morning that lasted, 6:03 and 6:04 in the morning that lasted 9 seconds and 7 seconds respectively. Those calls were answered. Brian Albert's call wasn't answered. But previous to that call that Brian Albert ignored, there were 2 calls to his wife who would be sleeping next to him at that time. Now, 9 seconds and 7 seconds isn't very long. It's not long enough to say, oh my God, you guys get up, hurry out here. We just found John O'Keefe's body in your front lawn. It's not long enough to say that and to have a conversation about that, but it is long enough to say something like, listen, we're here. Don't come outside.
Oh my God, come on. Okay, I get it.
No, Nicole Albert.
I get it. It's the defense's job. It's the defense's job. I get it. But I mean, how man, I'm not a trial attorney, so I mean, I have to ask Natalie if you're allowed to make like grandiose speculations like that in a motions hearing. I'd have to ask Nat about that.
And Brian Albert, a sworn police officer, never came outdoors, even though the entire world of law enforcement and medical personnel and first responders were responding to his front yard where a dead body was. Never ever came outside. Interesting.
Curious. Isn't it weird? Isn't it curious? Doesn't that make you think? Yeah, usually when people say that, I always assume that people who say, isn't it weird? Don't you find it funny? Isn't that interesting? Doesn't it make you curious? When people say that, I just assume that they're pulling stuff out of their ass.
John talks about the 80 steps. He said this at the last hearing, and he said it again, he reiterated it again at this hearing, in terms of John O'Keefe's Apple Health data, trying to throw sort of this murky explanation into the mix that the steps actually occurred after he was already pronounced dead. There are obviously, his expert found him, our expert found him, there are data that suggests that steps were taken with that phone after John O'Keefe was pronounced dead. Those aren't incorrect data. That was incorrect policing. It was sloppy policing. Those aren't John O'Keefe's steps. He was laying in a hospital on his way to a morgue. God rest his soul. Those were Michael Proctor's steps. He clearly stuck John O'Keefe's phone in his pocket and started walking around. He didn't secure the phone properly, so the phone was still recording data. It doesn't know whose pocket it's in. So the steps that were after John O'Keefe was dead doesn't mean that the steps were incorrect or it's unreliable data. It means that it was in a different person's possession, Michael Proctor's possession. And that's his fault. Like I said, he just didn't secure the phone. With regard to Kerry Roberts, Mr. Lally just makes this pronouncement, as the Commonwealth is wont to do, just these factual pronouncements with no fact to support it. Kerry Roberts and Jennifer McCabe, quote, barely knew each other. Note we have 15 phone calls, 15 phone calls on the 29th between Jennifer McCabe and Kerry Roberts. Barely knew each other? If that's true, they got to know each other real quick.
Well, when somebody dies in the vicinity, then yeah, probably. I mean, all right. Let's continue.
With regard to the statements made by counsel on behalf of Mr. Albert, again, he indicates that no conversation. What I said in my papers, Your Honor, was there was no conversation, no evidence of any conversation between Brian Albert and Jennifer McCabe. Therefore, there was one unanswered call. That's all you should look at. Everything else is just cannon fodder. Just ignore it. How about the other 7 calls that were made and answered on January 29th between Jennifer McCabe and Brian Albert? He indicates that we lack specificity in our request. Your Honor, I have nary seen a more specific request ever. We have narrowed our request down to only communications and location data for Brian Albert's phone, and only for the time period between January 29th and February 5th. It couldn't be more narrow. It couldn't be more of a specific request. We're not asking for a free-for-all search of his phone. We're looking for communications and location data only, and only for the time period relevant to his involvement in this case. One of the things that counsel suggests is that the defense is entitled to put on whatever defense they want. We can have a third-party culpability if we wish. But we're not allowed to just go and pick and choose and just throw a dart and pick someone out randomly to invade their privacy. Well, first of all, we're not invading anybody's privacy. We're defending someone accused of murder. And we didn't just pick randomly. Brian McCabe is the owner of the home in front of on whose property a Boston police officer
Oh no!
took his last breath.
He had to correct himself there. It wasn't in front of the property. It was right at the far corner. Far corner of the property. According to my CSI investigative work. Based on the based on the statements made by the witnesses and the officer, that the body was found right around yonder, which is the far corner of the property. So obviously not, it's not like it was found here, but like here.
Murder and lay in that front yard of Brian Albert's house. Brian Albert is the owner of that house, and he was one of the last people to see John.
Good night, Colin. Thank you for the raid.
Literally with him just minutes before his death. Minutes before his death. He owns a home with 3 stories. We have evidence that just before his death, John O'Keefe took steps suggesting 3 stories, up or down. We don't know which. He owns a dog. We have specific evidence. Talk about specificity. Specific evidence from one of the country's leading pathologists indicating that John O'Keefe's arm was mauled by a dog. Brian Albert's dog was a 90-pound German Shepherd. Oh, and by the way, Brian Albert made sure to get rid of that dog in the months following John O'Keefe's death. After that dog had literally...
Again, speculation.
...for some 7 or 8 years. Or 6 or 8 years. The person that found the body along with my client, Jennifer McCabe, was frantically calling into the home, within minutes of finding the body.
Yeah?
Those calls were later deleted. Brian Albert later sold the very house
Oh God.
the crime took place, distancing himself further from the crime scene.
Oh my God.
The Albert family is also connected to, as we've gone into pretty specific detail, connected to the elite investigator in the case, Michael Proctor. Your Honor, I'm bringing up these facts, which the court knows, but it bears repeating only because Mr. Lally and Mr. Higgins have suggested that we just sort of pick somebody out of whole cloth to seek their information. That couldn't be further from the truth. Brian Albert is integrally involved in the death of John O'Keefe. He is implicated in the death of John O'Keefe. Jennifer McCabe is equally implicated in the death of John O'Keefe and the subsequent cover-up of that.
All right. Before I listen to the rest of this, I'll be right back. I'm going to see if I can find Winston. We probably need a Winston break. I'll be right back. Where's my elevator music? This is good enough. All right. Hi. Okay. To all you newcomers, this is Winston. He is my baby boy. Yeah. What? You mad? Huh? Baby boy. All right. Winston is about 11 going on 12. So I guess
It's
he's
9:30.
technically a
Maybe
senior
this is a
cat.
good spot to wrap up.
There's 5 minutes left of the hearing. So we'll wrap up after that. let's finish this up.
We are entitled to defend our client. It couldn't be more specific, our request. It couldn't be more narrowly tailored. And we couldn't need it more. It couldn't be more necessary for Karen Reed to defend herself. She's entitled to this information. She's constitutionally entitled to defend herself, and she's constitutionally entitled to this information. Your Honor, there's no question that we have sought to and have successfully narrowly tailored our request. To the court's satisfaction, we are not on a fishing expedition. We have sought very narrow data from Brian Albert's phone. We have sought very narrow data from Jennifer McCabe's cell phone.
Akira, thank you for the $4.99 super chat. I appreciate it.
To verify that which we know to be true.
Barry, my understanding is that the trial is set for March of this year.
We can't just walk into court, Your Honor, at a trial and start spewing things that we think might be true. We know them to be true. We have to have evidence to back those statements up. You know for sure that the Commonwealth is going to say, if we don't get these data, where's the evidence, folks? I can see him standing in front of a jury right now. Where's the evidence? Sounds to me like the defense is on this fanciful journey, trying to convince you of facts that they can't prove. We need to
fanciful.
Prove it. We have the ability to prove these facts. And that's why we're asking for these products, these things, and these records.
Okay.
I'll submit.
Thank you very much. Mr. Lally, any brief response?
No, Your Honor.
Mr. Henning, any brief response? All right. Thank you very much. Jim, I think we need a next date.
We do. Something in July. We're going to file further motions.
I'll take this under advisement.
Do you want to have a pretrial hearing? Do you want to do a scheduling conference? Something in July.
And it can be done by Zoom, Mr. Jackson?
I'm sorry, Your Honor.
It can be done by Zoom. I know I told you before, you don't need to always come out here. Good. Zoom.
Thank you. May I have just a moment to consult
Sure.
my calendar?
Oh.
If September's better for you, we can do that.
I'd really like to do it in July.
Okay, so let's do it.
We do July 7th.
No. 17, 18, or 19 of July, I was looking at. I just can't do that week of July.
What about the following week
Yeah,
after the
I can
18th?
do 11, 12, and 14.
No, I'm saying the following week after the 18th.
After that,
So that the week of the 24th,
of June,
July.
July. Yep, just not the 27th.
July 25?
July 25?
Is the Commonwealth available?
That's fine.
July 25. For what? Scheduling conference or
Pre-trial hearing.
pretrial hearing? Okay. Pretrial hearing, 7:25 and 2 p.m.
All right, thank you very much.
Thank you.
Goodbye.
Okay, so my understanding is that the judge granted the defense's motion Rule 17 motion for the animal control stuff related to the German Shepherd. But they denied Brian Albert's phone. I'm trying to figure out whether or not they denied Jennifer McCabe's phone access. I know they denied Albert's, but I can't remember if they denied or granted Jennifer McCabe's access. I can't. I'm trying. That's what I'm trying to find, but I can't find it. But I think that's a good spot to stop here. It's been interesting. Like I said, I'm still confused about the whole timestamps with the phone. But I'm sure I'll get explanations for people. The other issue, yeah, there was like one other issue that I had that the defense raised that I have yet to stumble on a satisfactory explanation from the state. I know it's there, but I can't recall what it is. But so far, based on the evidence, there's strong evidence against Karen Reed, but whether or not it raises to the level of murder, I don't know. That's kind of where I am right now, where I think there's enough for manslaughter. I don't know if there's enough for murder, or at least I haven't seen sufficient evidence to warrant intent. So that's where I'm at. But I want to thank you guys for watching. Also much appreciated. I'll see you guys sometime this weekend. Probably going to be streaming. I'm going to try and stream tomorrow night. Not related to Karen Reed. Gonna have, more relaxed, laid back, more fun times with some courtroom drama and courtroom antics. But you have yourselves a good night. Take care. Adios. I'll see you next time.